Good morning, folks. You're all very welcome to this webinar, the first hosted by the LSRA on introducing legal partnerships. Just a couple of housekeeping matters. The session is being videoed for the LSRA's YouTube channel. I'd like to welcome and thank Catherine White, our Irish Sign Language interpreter, who's helping us today. I'm going to speak for about 20 to 25 minutes, and then take questions for about 10 minutes following that. And if you have a question, feel free to enter it into the chat function. The questions are anonymized, and I'll hopefully be able to navigate the chat function and address your questions towards the end. And if you put them in the chat function, only I'll be able to see them. So it's great to see so many of you signed up for this webinar and to see the interest that we've had in it. And it's also great to see a mix of solicitors and barristers have shown interest in legal partnerships. So even if you yourself have no interest in ever forming a legal partnership or being a part of one, I suppose it's important for all legal service providers in the state to know what they are, because it's possible that you'll interact with them from time to time. And some of you may be briefed by them or act opposite a legal partnership in the course of your delivery of legal services. And some of you may be aware that a number of weeks ago, Simmons & Simmons LP became the first legal partnership in the state. So legal partnerships are no longer just exist in theory, they also exist in reality. So what am I going to talk about today? I'm just going to try and shuffle through the slides here. So today, what I'm going to do is I'm going to talk a little bit, provide a little bit of context for those of you who may be unfamiliar with the work of the LSRA. I'm going to talk a little bit about what LPs, legal partnerships, actually are, and the legislative framework that governs them. I'll go into a little bit of detail around the framework and how it operates in practice. I'll talk you through how to form a legal partnership, how to become a legal partnership, and I'll outline some of the research that we've done as to how legal partnerships may impact upon legal services delivery in the state. And then I'll end with some thoughts on how the legal landscape in Ireland is changing and how the work of the LSRA is also changing, with a little bit as a look to the future as to what the next steps are for the LSRA on its mission. So this slide is the preamble to the Legal Services Regulation Act 2015. And most of the talks that I give and most of the CPD presentations that I deliver are around our complaints function. It seems to be the thing that most of the public and legal practitioners are interested in. But it's easy to forget, and I think this slide shows that the Legal Services Regulation Act 2015 introduced some other sweeping reforms of legal services delivery. It established the Legal Services Regulation Authority, but it also established the Legal Practitioner Disciplinary Tribunal, the Office of Legal Cost Adjudicator. It introduced new cost transparency measures for legal practitioners and a new system for the appointment of persons to be senior counsel, allowing solicitors senior counsels for the first time. But also included within the 2015 Act, and as I said, as part of the wide range of sweeping reforms that were introduced, was that provided for new structures in which legal practitioners may provide services together or with others. And it also introduced the role of practicing barristers. It's a little bit on the role itself, because the role is particularly germane to the issue of legal partnerships. So the role of practicing barristers was introduced by the LSRA 2018. There's now over 3,000 barristers on the role of practicing barristers. And what it does, the role, is that, yes, it's a regulatory tool that actually identifies who fall under the regulatory scheme of the LSRA. And it also is a consumer protection measure in that consumers can check the role to see if the person they're engaged with as a barrister is entitled to provide legal services in the state. But it also widens the definition of barristers and recognises barristers as practicing barristers who are employed and who are perhaps outside the Bar of Ireland, and recognises that those barristers in employment and outside the bar can still provide legal services. And the new structures that are referred to in the Act are legal limited liability partnerships, of which is currently 477 in the state, legal partnerships, which is the focus of this morning, and then multidisciplinary practices, of which I talk a little bit more later on. So the LSRA then has 6 objectives, which is the lens in which the LSRA views the world and all the work that we undertake. So the questions that we ask ourselves as we approach any work is the work being delivered in line with these statutory objectives? And that includes the complaints function, all the research that we undertake, and the introduction of new business models. So as we were introducing the new business model of legal partnerships and going back to the objectives, we had to look and see, does it fulfill what we're required to do, mandated to do under the Act? And you'll see there that what that means is it requires balance. It means we've got to balance protecting and promoting the public interest with supporting the proper and effective administration of justice, which protect and promote the interests of consumers, but also encourage an independent, strong, and effective legal profession, promoting competition in the provision of legal services. So there's almost an element of our work that fits with the Hippocratic Oath, and that first, do no harm. And we had to, as we were going through and establishing the framework of LPs, we had to make sure that anything we did hit those 6 statutory objectives and achieved what we're set out to do. And this also sits elsewhere within the LSRA's DNA and framework. Innovation is one of the LSRA's values. Encouraging innovation and advancement in legal practice models is also and has been a strategic priority for the LSRA over the course of its last 3-year strategic plan. So the context then for the delivery of legal partnerships is that it's part of the 2015 Act. The LSRA is mandated to do it and to introduce it, but also it feeds into our statutory objectives and our values. So legal partnerships, what are they? So, as I said, legal partnerships are mandatory under the Act. We have to introduce them. A legal partnership is a partnership formed under law, a written agreement by 2 or more legal practitioners for the purpose of providing legal services. And at least one of the legal practitioners has to be a barrister. So, as I said, the introduction of legal partnerships is a requirement under the Act, but it's also in line with modernisation that occurs in other jurisdictions. You'll notice that in England they have a thing called ABSs, which is alternative business structures. And Judge Twomey, at the launch of legal partnerships in October, described and made a parallel between legal partnerships and Oscar Wilde's famous quote, "The love that dare not speak its name," and that in other jurisdictions it has been common for barrister and sister partnerships to come into place, but in Ireland it seemed to take quite a long time for it to actually come to pass. So who can form a legal partnership? You see there the types: barrister-barrister partnerships, where just multiple barristers can come together to form a partnership; a barrister-solicitor partnership; barrister-barrister partnerships with solicitor employees; or barrister-barrister partnership with both barrister and or solicitor partnerships. And there has to be at least one barrister within the partnerships, and that barrister has to be on the roll of practicing barristers. I'm sure you're all aware of the obligations upon barristers that if they wish to provide legal services in the state, they must be on the roll of practicing barristers. That's a criminal offence if they don't. And the solicitor must hold a valid practicing certificate. Now, we were ready to introduce legal partnerships some time ago, but there was a requirement for an amendment to the 2015 Act, which had to wait until the Court and Civil Law Miscellaneous Provisions Act 2023 to introduce that amendment to allow us to introduce the framework. But what that meant was we had an extended period for statutory consultation and reporting. And if you go to our website, www.lsra.ie, you'll see 2 reports that we published in 2017 on the operation and regulation of legal partnerships in the state. That was following a review of practices elsewhere and a extensive public consultation. And we also conducted extensive public consultation in the run-up to the introduction of legal partnerships, including significant engagement with the professional bodies and public consultation as well, all of which was used to inform the framework itself. So this is the framework for legal partnerships. You'll see there's 3 sets of regulation and the code. And as you mentioned earlier, the role of practicing barristers also feeds into this, because it's those that are present on the roll that they're entitled to form a legal partnership. So these regulations, and I'll go into these in a little bit of detail, but obviously more information available on our website. So the Legal Partnerships Regulations 2024, and these set out the requirements for the establishment and the regulation of legal partnerships. They also outline the obligations on partners and include the notification process by which you become a legal partnership, and the fee that needs to be paid, and the requisite forms are also included as appendices. And then you have the Limited Liability Partnership Regulations 2024. And what these do is we've had limited liability partnerships in the state for some time, and as I said, 447 currently on the roll. And these regulations allow, and have been updated to allow, that legal partnerships that are formed have the ability to operate with limited liability. So it just allows the process that once a legal partnership is formed, it can then apply for approval to operate with limited liability within the state. And that is designed so that it can be seamless. So if you're an existing limited liability partnership and become a legal partnership, that you can retain your limited liability status. The professional indemnity insurance for barristers regulations, the LSRA has responsibility for the setting of the levels of professional indemnity insurance required by barristers in the state. Generally speaking, for legal partnerships, if there's a solicitor involved in the legal partnership as a partner or as an employee, the legal partnership has to comply with the regulations made by the Law Society in relation to professional indemnity insurance under Section 26 of the Solicitors Act 1984. Where it's a barrister-only partnership, then they have to comply with the regulations made by the Legal Services Regulatory Authority under Section 47 of the 2015 Act. And that reflects the different levels of risk, and also the fact that solicitors can hold clients' money, and barristers are prohibited from holding clients' money under the 2015 Act. And finally, the Code of Practice for Practicing Barristers. It's a new code which is included to cover barristers working in legal partnerships as partners or as employees, and also barristers working as employees elsewhere in the state. And under Section 22 of the 2015 Act, the authority can issue a code of practice where it considers it necessary to do so for the purpose of setting and improving standards for the provision of legal services in the state. It doesn't replace the existing codes, so the Code of Conduct for the Bar of Ireland still applies to Bar of Ireland members, and the Professional Code of the Honourable Society of King's Inns also applies to all barristers called to the bar. Where there is a conflict, however, the LSRA's code prevails, and where any of the codes are in variance with the Act prevails. I would state, though, that a lot of the public consultation we did was to try to ensure that there are no conflicts between the different codes. So our code is not intended as an exhaustive statement. It applies to every barrister on the roll, including employed barristers. The main sort of sections it details requirements to practice as a barrister, including the obligation to ensure your name is on the roll and to keep your details on the roll updated. It includes a mandatory requirement of professional indemnity insurance that meets the standards as allocated. It has sections that cover the conduct of work, rules regarding interaction with witnesses, rules regarding settlements and negotiations, a specific code in relation to criminal cases in relation to taking instructions, your required presence during the trial, how to deal with confessions, guilty pleas, and obligations post-conviction. It also has sections relevant to CPD, need to maintain your CPD as a barrister, the restrictions, as I mentioned, on holding clients' money, the requirement to pay the annual levy of the LSRA, data protection, disclosures of your fact with your partner in a legal partnership, and professional indemnity insurance for barristers in employment, maintenance of legal education, and other obligations. As I said, not an exhaustive statement of everything the barristers have to comply with, but does outline the key obligations that each barrister, including those within legal partnerships, have to comply with. So then the key element and the features of legal partnerships. So the barrister in a legal partnership cannot hold client monies. As I said, there's a restriction under the Act, under Section 45. And in 2017, the LSRA did a public consultation and examined the issue as to whether the restriction of barristers holding clients' money should be lifted. And the result of that was the recommendation that it shouldn't be lifted at this time. So barristers who go into partnership with other barristers cannot hold client monies. They can, of course, obviously be paid and remunerated for their work, but they don't hold or operate a client account. When a barrister-solicitor partnership is formed, the solicitor can hold the client account, but the barrister can't have any hand, act, or part in it, which is why, obviously, it's important that a barrister-solicitor LP can apply for LLP status. There are obligations around client confidentiality, including responsibilities between the partners as to what can or cannot be revealed in relation to client confidentiality and dealings. There's obviously an obligation for all partners and any employees of legal partnerships to conduct themselves professionally and ethically and in lines with the appropriate codes of conduct. The Code of Practice for Solicitors, the Code of Conduct for Solicitors or Professional Conduct for Solicitors, 4th edition, still applies towards the solicitors, and the codes as I outlined for barristers still apply where necessary. All legal partnerships must maintain a register of clients. The anti-money laundering requirements that exist for both solicitors and barristers separately, and there's different requirements for each. They all also apply towards legal partnership, including the Know Your Client requirements and the checks that are required of solicitors when clients come to them to make sure they're not falling foul of any of the anti-money laundering requirements. The trust must provide the name of all legal practitioners in the partnerships to the client and indicate whether they are barristers or solicitors. Each legal partnership has to have an internal complaints procedure in place and to inform the client of the same. And then there's a restriction on access to the compensation fund. And what that is that the compensation fund is only available to members of the public where there's been fraud on behalf of the solicitor. There is no equivalent in relation to barristers. So each client of a legal practitioner, when it's a solicitor, barrister, legal partnership, have to inform the client as to the restriction that's available, that's on the compensation fund, i.e. that it's only accessible in relation to fraud by solicitors. Excuse me. Okay, so those are the key features. Becoming a legal partnership. And I would say from the start then that the process is permissive under the Act. The Act speaks of notifying the authority of your intention to provide legal services as a legal partnership. It's not per se an application process, but with a couple of very limited restrictions. And what's required? There has to be a written agreement between the partners, and the LSRA isn't required to under the Act and doesn't intend to police the written agreement. We're not examining the written agreement to see between partners to see whether or not it's appropriate or detailed or fair between the partners. We don't police that. We require just a sworn declaration that a written agreement between the partners is in place. We then notify the LSRA of your intention to provide legal services and provide the required commensurate notification fee of €575. You also have to indicate what name the legal partnership will operate under. And this is the only aspect that the authority has jurisdiction over as to whether or not we can refuse the legal partnership. So under the legal partnership regs, it sets out the criteria for the naming of the legal partnership, and it can't be anything offensive or misleading. So if you intend that the name of the legal partnership is simply the names of the partners within the legal partnership, then that is automatically can be not automatically registered by the LSRA as an LP. But if your name is something other than existing of the names of the legal partnerships, then there's an approval process. So, for example, Simmons and Simmons LLP, no need for a notification process for them. That was the names of the partners existing. But if someone had applied to us and wanted to be called the number one law firm, all others are terrible, LLP, then that would have to go through a process whereby we'd look at the name and see whether it meets the criteria and will be unlikely to be passed. The LSRA is required to maintain a register of legal partnerships, which is now on our website, www.lsra.ie, and it includes the names, the address of the legal partnership, and the names of the partners within that legal partnership. And there's a requirement to update the LSRA at any point should the status of legal partnerships actually change at any point. And as I said, the legal partnerships once established can then apply immediately for LLP status, and we have process in place to make sure that that is seamless, that there's no issue that anyone would lose their LLP status by dint of an LP becoming a legal partnership, or if a legal partnership wishes to apply for LLP status, that we can assist in making sure that's as joined up a process as possible. So legal partnerships who are also operating with limited liability status will exist on both the legal partnership register and also on the register of LLPs. So that's how you become a legal partnership. And just this is in relation to the research that we've done on legal partnerships before we introduced them into the state. So as we were preparing to launch the legal partnership framework, as we've just gone through, we did an extensive amount of engagement with the public, with consumers, and also with legal practitioners to see what the possible interest within the model might be. We were always, over the years in developing the framework, we were always mindful of the fact this would not be something that would be a huge uptake on immediately. Whenever we introduced LLPs, there was a considerable uptake within the first year, but we understand that this is something that will probably have a slower burn to it. And that was seen in other jurisdictions, including the alternative business structures I mentioned earlier that exist within the UK. So as I said, we undertook extensive public consultation. We did qualitative interviews with barristers over a period of time. From that research, we found that barristers believed, in the main, that there'd be three types of legal partnership that they envisaged could be introduced. One, where an established firm would bring on a specialist barrister as a partner. And secondly, where junior barristers may group together and to save costs and to go into business as a partnership together. And then thirdly, potential for whether there's rural family firms where a member of the family has become a barrister and they wish to work within the family firm, that they can be brought in as a partner. We also conducted a survey of solicitors using Ipsos. You see there 213 solicitors across 201 firms. 61% saw legal partnerships as a positive development. And then there was this statistic that 1 in 5 effectively thought that their existing firm will become a legal partnership within 5 years. And the LSRA has a responsibility under the Act to, I think it's every 18 months, to review the operation of legal partnerships as a model and to report to the minister as to how it's going. So over that period of time, we'll see how valid that stat is and how true it is to see how many firms actually take up legal partnership status within the next 5 years. So on the positives, some of the legal practitioners saw that LPs might lead to greater efficiencies and cost savings, but it wasn't obviously universally positive. There were some concerns about barrister independence and then that the introduction of legal partnerships might reduce access to some of the top specialist barristers, which hopefully we've addressed within the framework, including within the legal partnership regulations and the code of conduct for barristers. And then in another piece of work that the LSRA has done, which is the Breaking Down Barriers report, where we've done extensive research to see how we can assist legal practitioners in the first early years of their career to maintain their career within legal services delivery, but also to see how we can improve socio-economic and other diversity amongst the legal profession. But amongst that research, we found that we did a survey of barristers, and 74% of barristers surveyed said that they felt that the working environment for barristers needed improvement. And of those 74%, 69 of them favoured new business models, including legal partnerships, as a way of improving the legal service delivery. So that's the research statistics. I'm just going to talk about some of the future work of the LSRA very, very briefly at this point. And just a reminder, if you have any questions, to put them into the chat function, which I move to just about 3 or 4 minutes, and to see what questions need addressed. So what's next for the LSRA? The MDPs, or multidisciplinary practice, which I mentioned earlier on, is one of the other new models of legal service delivery. We've done some work on this dating back to 2017 and 2018, and we've submitted a report to the Minister which said that multidisciplinary practices should only be revisited once the LSRA had established LLPs and legal partnerships, which obviously now we've done. So we'll revisit the MDPs in the near future. We have, as I mentioned, the work around the barriers research, which we've done, where we've made 32 recommendations to the Minister about how we might improve diversity and address those early career challenges that I mentioned earlier on. We also have our work in relation to what is the Legal Practitioner Education and Training Committee. This is recommendations arising for our work in relation to setting standards for education and training. The two main recommendations being the introduction of a competency framework for all legal practitioners, and then the introduction of a committee through which new delivery providers for legal education and training could enter the market. And all of that work is currently underway. We'll be launching the authority's inspections function, hopefully before the end of this year. And the first inspections of legal practitioners in relation to complaints will be carried out. And then we're at an interesting time for the authority itself, in that we have a new authority, new chairperson, and new members can be announced in the next couple of weeks. We're told the announcement is actually imminent. And then, as I mentioned, just to finish on a slide that looks at the changes and alterations and what's happening in the legal landscape in Ireland. And I like this slide simply because it asks some interesting questions about the state of legal services and what actually might be coming to us in the future and what it might already be here. So one of the key things is we've got 5 different generations in the workforce, and things are changing as to how people view careers, how they view work itself, what they're looking for motivation and work-life balance, and also how they view ethics. One legal practitioner said to me, and it's something that stuck with me, and forgive me if you've heard this before in other talks that I've given, but legal practitioners said that whenever they were growing up, whenever they were looking to law as a career, they looked to Atticus Finch from To Kill a Mockingbird, Gregory Peck, who played him in the movies, as the bastion of providing protection for those whose civil or human rights may be being downtrodden. And that was the model that they had for the delivery of legal services, the model they had as a lawyer. But they queried as to whether the model that new generations are looking to is Rudy Giuliani, outside the garden centre, hair dye running down the side of his face, defending Donald Trump. Then there's artificial intelligence. This is going to be a new challenge in every talk and every CPT event I appear at. There seems to be some sort of introduction or some level of AI being discussed. And you may be aware of the case in Schwartz and LaDuca, the 2 lawyers in the States who submitted a submission to the court in relation to a case they were involved in, a negligence case involving an airline, where they generated the submission using artificial intelligence, but unfortunately had used predictive AI and which would result in the fact that a lot of the submission was fake. It was made up. That it generated fake case law, but based on real judges and real judges' names. And Schwartz and Luca were both fined by the regulator and made to apologise. There's some at the moment in the UK. They're considering looking at blockchain as to whether blockchain technology would actually allow for legal practitioners to not have client accounts and to be able to do things like conveyancing, etc., without recourse to clients' accounts, and whether that would have an impact upon the professional indemnity insurance required of solicitors. And also, as I said, new types of conduct complaints. And it's always astounding to me in any of the regulatory environments that I've worked at, the different methods that people can find to get themselves into trouble. And that includes recently with new engagements, way to engage in social media and the inappropriate use of social media, the strategic litigation against public participation, which is emerging in this state as an issue, and then delivery of legal services in a political context. And then one of the big issues that we keep getting told about is around the fact of legal deserts, the fact that there's very few criminal practitioners coming through anymore, and where have all the family lawyers gone? And obviously, introduction of elements such as legal partnerships is a way to address the delivery of the provision of different service delivery models in this state. So I'd like to say thank you all for coming once again, for attending the webinar, and for your interest and engagement. And thanks to Catherine as well for all her efforts in keeping up with my Northern Ireland accent. So thank you, folks.